So what Rick and I are talking about is Davis-Stirling, and I think Rick gave you a little bit of an overview. This is going to be sort of a more in-depth overview, but it really is going to be an overview. As Rick said, Davis-Stirling is about 80 pages. It's recently been re-codified, which means they've basically reorganized the entire statute, hopefully to make it a little easier to use. But that also means that we all have to get used to finding everything that we know is there. It's all in a new place in the Civil Code. So somebody asked about where you can get a copy of Davis-Stirling. Right now, the easiest way to get a complete copy is to download something that's called Assembly Bill number 805. That was adopted last year by the Assembly. It goes into effect on January 1st of 2014, so right around the corner, and it incorporates everything that was in Davis-Stirling and a few changes, and as I said, it puts it all in a different place in the Civil Code now, but it's all in one place and it's all reorganized. So it's a thick document. It's not that easy to get through, but if you're looking for something, that's where it is. So if you could go to the first slide. So just by way of background, Davis-Stirling was adopted in 1985, and it really came out of a desire. There was a lot of statutes in the California codes dealing with condominiums and planned unit developments, but they weren't really coordinated. There were bits and pieces in the Civil Code, there were bits and pieces in business and professions, and so Davis-Stirling was an effort to bring it all together in one place. It was also an effort to bring together all of the statutes that apply to what are considered to be similar types of developments into one place. So the problem with Davis-Stirling is it lumped a lot of different types of development into a single statute. So what you have is a statute that applies to condominiums, planned developments, community apartment projects, and cooperatives. And just to note, Davis-Stirling uses the term stock cooperative, but it encompasses limited equity co-ops. So all co-ops are going to be subject to Davis-Stirling. The problem with the approach to Davis-Stirling is it does not distinguish between cooperatives and condominiums, which are very different, as I think we all know. It also doesn't distinguish between small developments. You know, Rick was talking about a 3-unit cooperative and 400, 500 unit developments, or what Davis-Stirling also encompasses is planned unit developments, which are those large subdivisions. If you go out to the Central Valley and you see, 1,000 homes that sprung up out of a farm field, that's probably a planned unit development, and that is subject to Davis-Stirling too. So you are being lumped into a statute that is designed to cover a lot of different types of developments, many of which do not look anything like a cooperative. You are also being lumped in with a lot of developments. We've seen huge growth in California of these large subdivisions, and they are really the developments that are causing Davis-Stirling to constantly be amended. Because if you own your home and you live in a 1,000-unit subdivision, your homeowners association functions like a small government and governs a lot of what you do. And so Davis-Stirling is constantly being updated to address issues that come up in those subdivisions, but those issues are not really the issues that you all are facing. So the challenge we have with Davis-Stirling is taking cooperatives and making them fit within all of the regulatory requirements of Davis-Stirling. And it's not always easy, and we're going to go through some of that, and you'll see that some of the requirements may seem extremely onerous. And the idea really is that nobody was thinking about you all when they were writing all this stuff. So we kind of do our best. Our idea with this panel is really to give you the tools so you understand what the statutes require, what the rights are of members, what the board members' obligations are with regard to Davis-Stirling, so that hopefully we can make it work. Just to note, now hang on just 1 minute, I do want to note, I mean, the main purpose of Davis-Stirling is it is a consumer protection statute. So it's really geared towards protecting member rights. So when you're looking at the requirements of Davis-Stirling, if you keep that framework in mind, it at least helps it make some sense when you start to think that this is really overwhelming. That's the idea, that each of the members that buys into one of these communities has their certain rights, and those rights need to be protected. So Rick and I are going to highlight the major provisions of Davis-Stirling, and I just wanted to sort of lump them together and give you a broad overview. There are disclosure requirements. There are requirements that you must disclose certain information to new purchasers into your community, and also requirements that members receive annual disclosures, and we'll go through that. There are requirements about alternative dispute resolution. So if the cooperative has a dispute with a member, there's certain requirements around that. There are assessment requirements in terms of how you implement assessments, how you increase them, how you notify members. Voting requirements, I think almost everybody in this room has probably struggled with this one, and that's what Rick has been doing for you all, is handling your elections, because we have fairly recent requirements with regard to elections. There are requirements about how operating rules that impact certain aspects of life within your community, have to be adopted and noticed to the members. There are also requirements about how your board meetings are conducted, and the requirement that they be open to your members and members be notified of what the actions the boards are taking. Those are sort of the big picture items. There's a lot more in Davis-Stirling. There's lots of little requirements scattered throughout the statute. We're not going to go through all of them because we'd be here all day, but you need to be aware of the fact that if your board wants to take a certain action, you probably need to make sure it's allowed under Davis-Stirling. And if you as a member have some concerns about how things are being done within your cooperative, you may want to consult with Davis-Stirling first to see whether it governs that, because, as I say, it gets changed all the time and they keep adding requirements. So just to note, typically the Davis-Stirling requirements are included. They may be included in a very summary fashion, or they may be included with a lot of detail in the cooperative's bylaws. In your articles of incorporation may have some information. The occupancy agreement may include some of the requirements with regard to the members' rights. There's also a document called the declaration, which very few people even know exists, that is recorded against the property, that would include some of the Davis-Stirling requirements, hopefully would be duplicative of the bylaws, because most people don't ever look at their declaration. And then your operating rules, that we're going to talk about a little bit more. So the first area that we wanted to talk about was disclosure requirements. And as I said earlier, there are two levels of disclosure. The first level is when somebody is buying into your cooperative, wants to become a member. Davis-Stirling requires a pretty significant disclosure package be prepared for that new member. The idea behind it is a good idea. You have to remember that you as a member of a cooperative are selling an interest in real estate. And if you were selling a home, you would have a lot of disclosure requirements. This is the substitute for those requirements that are contained elsewhere in the statute, and they are designed to ensure that the person purchasing knows exactly what they're buying into. As a member who's selling your share, you should want to comply with this requirement. And the reason is, if you sell your membership to somebody and they do not feel that they have received all the information, they may have the ability to come after you if they feel like financially this was not the deal that they thought they were getting. So it is an important step to follow through on. and make sure that it happens. Often your cooperative will take care of this for you, but you as the member should pay attention to this when you're selling your membership share, because ultimately the transaction is between you and the new member for the most part. So what do you need to provide to the prospective purchaser? You need to provide all the governing documents. So the list on the prior slide, your bylaws, your articles, your occupancy agreement, your declaration, which people never know exists, and your operating rules should all be provided to the prospective purchaser. If you have any restrictions on occupancy in the cooperative, so if your cooperative is limited to senior citizens, if your cooperative is limited to people with certain income restrictions, anything like that, you are required to disclose. We're going to talk about this a little bit more, but you also need to provide the prospective purchaser with a copy of the annual disclosure that all members receive, and we'll talk about what goes into that. You need to provide them with a statement that is prepared by the cooperative association that says exactly what the monthly assessments are and whether there are any unpaid assessments that you owe. So whether there's any debts owed to the corporation, and also whether there are any fines owed related to the unit. You are also supposed to provide them with any information if there's a proposed assessment increase that has been passed by the board but has not been implemented yet. So if your board has adopted a budget, but the budget is for the coming fiscal year and that includes an assessment increase, you need to disclose that to the purchaser. If there's any restrictions on renting the units, this is an area that a lot of our cooperatives have been struggling with, of restricting subletting. If your bylaws or your occupancy agreement contains a restriction on subletting, you need to disclose that to the prospective purchaser as well. And then if you, as the selling member, are in violation of any of the rules and you've received a notice of violation, you need to disclose that to the prospective purchaser. So it can be a pretty thick package. Often, as I said, the cooperative will prepare it for you as the member and distribute it to the purchasers, but if they don't, you really need to make sure that it happens. And it is really helpful if your cooperative does it, because running around and getting all the information can really be a hassle. You as the member have the obligation, but you can request that the corporation prepare this. The corporation can charge you a reasonable fee. They do have to disclose to you the fee for producing each document that is required. And there actually is in Davis-Stirling a form that the corporation is supposed to prepare that says exactly what they charge for each document that they may produce for this type of disclosure. So if you need them to provide the governing documents, they're supposed to list for each one of those documents what the cost is of copying and providing it to you. So if you're getting ready to sell your membership unit, I would suggest you contact your management and you check in on the purchaser package, make sure it's in order, make sure that they've got it ready to go so that when you get down to finding a purchaser, that's all taken care of. Okay, so the other area of disclosure and the area that is a significant task for all cooperatives is the annual disclosure. And this is one of the things that Davis-Stirling included from the get-go. It has been expanded over the years to add more and more requirements. But the idea here is to make sure that members are fully informed as to the financial health of their cooperative, the financial health, the physical health, and any rules that they really need to know about. So on an annual basis, the cooperative is required to distribute a disclosure package to each member. What does it need to include? The first thing is the operating budget that for the coming fiscal year. So your board is supposed to have adopted the operating budget, and then they are supposed to distribute it to all of the members. Another area of significant disclosure is reserve requirements, and this is an area that is challenging for a lot of cooperatives. It's also an extremely important area. Your cooperative association is responsible for maintaining the major components of your building, and in order to ensure that that happens, good cooperative management would dictate that there be some reserves on hand so that when the roof needs to be replaced, there's adequate money. So instead of saying to the members when the roof needs to be replaced, you all have to provide us with thousands of dollars right now, the idea of reserves is that every month you all pay into the reserve fund so that when those repairs come up, there's adequate money and nobody is hit with some extremely high assessment. Davis-Stirling doesn't require a certain level of reserves. What it does require is that your board on a regular basis do at minimum a visual inspection of your property, that the board review the major components of the property during that visual inspection, and that the board come up with a reasonable analysis of the cost of replacement of those major components and how that cost of replacement correlates to the reserve funding that the board is building into every budget. And you as members are required to get an annual statement that includes how the reserves are calculated, how much is in reserves, what the cost of major components are that are coming up on the horizon that need replacement, and how that correlates to what you have in reserves, so that you can see on a regular basis, oh, my cooperative is fine, we have a lot in reserves, we should be fine when the roof comes due for replacement in 5 years. Or you can see that maybe that's not true, and we are going to need to do a special assessment to actually take care of some of the repair costs. So that's all required as part of the annual disclosure to the members. It is an area that I think is probably neglected a lot because it is very complicated to sort of fit all the pieces together. So the question was, if the reserve information is provided and the members are voting on what needs to be done in the cooperative, can the members postpone what needs to be done to correlate? Right, well, there's a couple assumptions in your question that I want to, first of all, Davis-Stirling, once again, does not require any specific reserves. It requires disclosure as to what is included in the reserves and how those reserves correlate to the repairs that need to be done. The other thing is typically the members don't vote on the repairs that need to be done. That really is a board function. So the board has to make those decisions. Where a vote might come in is if you have a really significant repair and you do not have adequate reserves, the board has the option of assessing the members what's called a special assessment. So a one-time assessment to pay the cost of those repairs. As special assessments, if they exceed a certain level, have to go to a vote of the members. So if the members, let's use our roof example, if that is a very expensive cost and you don't have the reserves and you need to do a special assessment, and that special assessment is going to exceed 5% of the cooperative's gross annual budget, you have to have a vote of the members. And if the members vote it down, you're not going to get the repair. You're also going to have a leaking roof. That's the reality of what's going to happen. So the members, yes, they have some say, but your investment in the community is going to deteriorate. Yeah, they're in compliance, but it's not a good situation. Davis-Stirling doesn't require specific repairs. It doesn't require specific reserves. It tries to create a structure where you will end up with good management, but it doesn't require that. Sorry. So the question is, reserves are above and beyond the monthly assessment. Typically, the reserves are included in your monthly assessment. It's just part of, if you're paying $500 a month, the co-op may set aside $25 of that to go into reserves, and the other portion of your assessment pays the day-to-day costs. Davis-Stirling? No. The question was, is there any cost containment mechanisms in Davis-Stirling? And no, that's really up to your board and your management. Well, yes and no. So the question is, you need somebody with accounting expertise and construction expertise or some sort of building expertise to describe what's needed. Let me just say, Davis-Stirling, when it was first passed, had very broad language about a reserve study, that you were required to have a reserve study. It caused a lot of anxiety amongst all common interest developments because I can tell you when Davis-Stirling passed, I have a co-op that was in San Francisco. They went to hire somebody to do a reserve study. They wanted to comply, and the bid they got was $1 million. Because a real full-blown reserve study looks at every aspect of your building. It will look at every wiring, every mechanical function in your building and project out over a 30 or 40-year lifespan the replacement of every little thing. And it's very detailed, and engineers used to prepare them. That obviously was a huge burden on cooperatives. It was a huge burden on condominiums. Nobody was doing it. So the statute has been amended, and what it now says is you'll do a visual inspection. It doesn't really say a reserve study, and it really is up to your board as to how detailed that study is, but they are supposed to do a visual inspection of the major components. Now, does that mean your board goes out and walks the property? That probably complies. But, some co-ops actually bring in somebody like a contractor or some, building systems engineer to look at the major components, still doing a visual inspection because, once you get into anything beyond that, you're really increasing your costs. But the idea is to have somebody look at it and at least take a reasonable estimate of what's happening in the building. So it's not as detailed as it used to be, or it's not as onerous as it used to be. But, good management would dictate that you would have somebody that actually understands buildings. I could go look at your buildings if I was on the board, but I wouldn't know anything. I couldn't tell you if my house needed a new roof, so I couldn't tell you if your building needed a new roof. So that's not very helpful. But if you have a property manager who's, also works with the maintenance aspect of your building, that might be the person to do it, or you might bring in a contractor from time to time. So that's really something that's up to your board. Davis-Stirling doesn't say that you can't spend the reserves in a way different than you originally contemplated. You are required as a board, if you're going to use your reserves, there are certain provisions in Davis-Stirling about making sure the members have notice of the use of the reserves. So that's the main thing is, it's a board decision, but the board is supposed to keep the members abreast of how they're using the reserves. And if you are a HUD co-op, HUD does dictate your reserves, period. And you are required to set aside an amount. My second comment on that, and HUD dictates how much you can charge your residents, so you can't really increase those reserves, but those HUD requirements are woefully inadequate for the most part. So it's always a problem when you have a major component that needs to be replaced and you don't have enough money in a HUD co-op because those reserve requirements were set in the 60s and 70s and costs have gone up. So that's a struggle that we've had with a lot of our HUD co-ops is how do we actually pay for things. In terms of annual disclosure, your board is also supposed to provide you with a financial statement for the prior fiscal year so you can see how the co-op actually performed. You're supposed to provide a statement to the members of the cooperative's policy for collecting delinquent assessments in terms of fines, any penalties that accrue, the timing. If your cooperative allows people to enter into payment plans and has rules about that, that's also supposed to be disclosed. You're supposed to disclose a summary of the cooperative's insurance policies. And there's some very specific language that needs to be required with regard to the insurance policies. This is supposed to be an annual disclosure. So even if your insurance policies don't change, you're supposed to do it every year. That's a question I always get. There is a specific statement in Davis-Stirling about delinquent assessments and foreclosures. That is required to be distributed to your members every year. It is, for cooperatives, something that is semi-meaningless. Typically, if a member is delinquent in assessments, we don't use the foreclosure process, but you are able to use it, and the statute, this is the one-size-fits-all approach of Davis-Stirling, the statute requires that you provide this notice to your members every year, even though we would rarely use it. Delinquent assessments are your monthly charges that the cooperative charges you to live there, so it correlates to rent, your carrying charges. So if you're late in paying those, late fees, I mean, late fees are what are collected if you don't pay your monthly charges. Well, some people call them carrying charges, some people call them assessments. They may look like rent. I mean, it's what you pay to the co-op once a month. Yeah. So the question was, how does the board get all this information if they have a managing agent? Your management agent most likely prepares these annual statements and distributes them. That should be part of their task. Okay, so which management agent? The board needs to direct who does it. I don't think it matters. I mean, but you gotta make sure somebody does it. So it's up to the board to determine, and it should be in one or the other's contracts as to the services they perform. The annual disclosure requirements do not include a requirement that you provide the management contract, but there is another provision of Davis-Stirling that members essentially have the right to review almost all records of the cooperative. There are very few records that members are not entitled to review, and the records they are not entitled to review primarily involve personal information that could lead to identity theft. And member discipline records that could be embarrassing to other members. So if there's a contract that you want to review, you as a member are entitled to review that. If there are financial records you want to review, you are entitled to review that. The member inspection rights in Davis-Stirling are extensive. Very detailed, very significant requirements on the cooperative to comply with, and to comply with them in a timely manner, so that you as members have access to the information. This is your home. You should know what's going on. So if you want the management contract, you should ask for it. Okay, finally, you're also supposed to receive notification each year of how you can receive minutes of all the board meetings so that you know what is going on at the board. You are entitled to get those. Just a few other areas, and we'll talk about this a little bit more. The annual disclosure is supposed to include a summary of the alternative dispute resolution process. This is a process that the members in the co-op the co-op has to make available to members to resolve disputes. If you are required to get the cooperative's approval to make physical changes to your unit, that process for obtaining that approval has to be disclosed on an annual basis. These disclosures, as I said, are supposed to occur once a year. That is supposed to occur no later than 30 days before the beginning of the fiscal year and no earlier than 90 days before the fiscal year. So there's a 60-day window during which you're supposed to receive the disclosures. Alternative dispute process, I'm just going to really go over this very quickly. It's a provision in Davis-Stirling that really is designed to ensure that members can quickly and hopefully cheaply resolve disputes that they have with the cooperative. So the cooperative is required to have an alternative dispute resolution process, meaning a way that you can be heard and air your grievances and hopefully resolve them without having to use the court system, which can be expensive. If a member requests the alternative dispute resolution process be used, the cooperative must use it. However, if the cooperative has a dispute with the member and the cooperative requests the alternative dispute resolution process, the member can refuse and require that the dispute be heard in court. The main requirements of the process are that it provide opportunities to be heard. It must have specific deadlines for resolving the dispute. The costs must be free of charge to the member. So it is supposed to be quick and cheap so the member can resolve their issues. I have to check that because this section has changed. I'm not sure if the cooperative has to get involved in member-to-member disputes. I'll look at that while Rick is talking. One thing I do want to note is the dispute resolution process doesn't apply if to the cooperative trying to collect funds that are owed to the cooperative by the member. So if you've not paid your monthly charges, the cooperative does not have to go through an alternative dispute resolution process before they initiate actions. So we talked a little bit about this. The other area that Davis-Stirling regulates is assessments, or your monthly charges that you charge members. Now, just to be clear, there are no requirements in Davis-Stirling about the amount of the assessments, but there are requirements about how the board goes about implementing assessment increases. And there are requirements that if there is going to be an assessment increase that exceeds a certain threshold, it must be approved by a vote of the members. So if your board is going to increase your monthly charges by more than 20% in a single year, the members must approve that. Otherwise, it's not a valid assessment increase. And there are also requirements on special assessments. These are one-time assessments that may be implemented to pay certain costs that were unanticipated. The board can implement special assessments, but if the total amount of the special assessment exceeds 5% of the budget, that also must be approved by the members. So this was the discussion we were having earlier. If you have a big repair and it's going to be really costly, you may have to get member approval before you can implement that. Davis-Stirling also regulates when assessments are late. They are late 15 days after they are due. This is different than standard landlord-tenant law, which generally in 3 days you could actually evict somebody if they don't pay their rent. Under Davis-Stirling, you have to give people at least 15 days sort of grace period. And so that's a budgeting issue for your board as much as anything, because if you can't start collecting and taking enforcement actions for 15 days, you have to factor that into your bill payment process. And then Davis-Stirling also regulates the amount of late fees. So they are limited under Davis-Stirling to a specific amount. So if you have questions about late fees, you might want to check Davis-Stirling.
I'm going to start by talking about elections. Again, it looks as if almost all of the co-ops here are operating under the new set of rules, and I've monitored the elections for most of you. But I'd like to start with the basic understanding that cooperatives are democratic organizations, and the members have a right to vote on many of the key issues. So Karen mentioned previously assessment, but obviously board of directors, any amendments to your governing documents, and one other point there is a grant of exclusive right to the use of common areas of the property. Now, I don't know if that happens much at your cooperatives, but many of the co-ops, in addition to your unit, you may have a private fenced-in area, either in the front yard or backyard or other. These are exclusive use areas of the common area. So any decisions about expanding those areas or providing that exclusive use must be covered. Where there are changes in the exclusive use, they must be, the members must be allowed to vote on that. So this portion of the act covers that. In 2006, there was a major change. Karen pointed out that there are constant changes. In fact, probably every year there are at least some changes to Davis-Stirling. But in 2006, there were major changes to the election procedures. And the board was required to adopt new set of rules. I think Karen also mentioned that typically your bylaws should reflect Davis-Stirling, but because there's regular changes, you really can't be changing your bylaws every year. So the board was required to adopt a new set of election rules and to reflect those changes. And in that case, those election rules take priority over the rules in your bylaws for addressing elections. And it covered a number of issues, but there were probably really two primary issues. The first, a co-op must appoint an inspector of elections. The election inspector then is responsible for really monitoring the entire election procedures. And the election inspector is supposed to be a neutral third party, an independent third party. And so it really can't be anyone who is currently employed or under contract to the cooperative. It can, in fact, be a co-op member if there's anyone living in a co-op who is truly an independent third party. They need to be, acknowledged by the membership as really being neutral, and that's often pretty difficult. But they also need to be knowledgeable about the law, and they need to be able to make kind of critical decisions, because the election inspector is expected to determine the validity of votes, the voting rights of any member, and so on. So it's really more typical that it be an outside party that is appointed by the board and conducts those elections. And typically, again, the election inspector will work closely with property management to make sure that adequate noticing is being distributed and that the ballots get out in the method, in the means that are required under Davis-Stirling. That person would be an independent contractor, yes. He or she would be appointed by the board and would operate, yes, essentially as an independent contractor. They're not an employee. Well, typically, yes. As someone who has done a lot of these elections, I can assure you it takes a lot of work, and typically that person will be paid. But you may be able to work out some other arrangements. The other major change in election law was a requirement that the ballots be distributed at least 30 days before the election. Now, most of you used to just show up at your annual meeting and vote. All happened in one day. Maybe you had proxies or some other way if you weren't able to attend. Sometimes the polls were open for the whole day, maybe from 7 in the morning to 7 at night, but it all happened usually on one day. Now the ballots must go out 30 days in advance. And since you've all been, or most of you have been through it, I'll go through this very briefly. The slide says what some of the basic requirements are, but it's sometimes helpful just to see it all visually. You all would get a packet that looks like this. You would open it and you would find inside 2 envelopes, a ballot, your ballot instructions, and then depending on your cooperative, usually each candidate has a way of expressing their why they're running. One co-op puts it all, just they allow a 100-word statement. Another co-op allows each member, each candidate to have a full-page flyer. But you then fill out your ballot, you fold it, put it into the blank envelope, you seal that, you put it into this second envelope, seal that, and this is really the critical one where here you must put your name, address, and signature. If that's not done properly, your vote will not count. Then these are, and this is all described in the instructions, the ballot instructions. These are returned either by putting a stamp on and mailing it. It's addressed to the election inspector, usually at the address of the cooperative office. You can usually deposit it in a box at the office, or again, there must be a public meeting properly noticed when all of the ballots are counted, and all members are allowed to attend. I know previously I sometimes did elections where it would be done in a closed room. You know, members could sit outside, but nobody was allowed to be present for the counting. Under Davis-Stirling, it doesn't work that way. All members are allowed to participate or to be present. When the ballots are counted, the election inspector will then separate these, put aside that envelope. You get a stack of these. This assures the confidentiality of your vote. There's no way of knowing who voted in this. You then open it. The election inspector counts the ballots, gives to the board of directors an official tally, and the board has 15 days to announce the results of that election. Then the next thing we'll be going to is operating rules. And operating rules really represent, you know, the basic policies of any cooperative. These are not kind of your day-to-day decisions, but these are the broad policies which Davis-Stirling refers to as operating rules that establish really how business, you know, the business of the cooperative is done, all the operations management and so on. So this slide indicates the kinds of things, again, under Davis-Stirling that are considered operating rules. Some of these we've talked about already: use of common areas, special use of separate interests. Those are your individual unit and your exclusive use. Now, these are not decisions about how you individually use it, but what the broad policies of how, so that everyone understands how those decisions are made. Member dispute, standards for delinquent payment plans. Again, not an individual payment plan, but what are the overall rules for developing those payment plans. Dispute resolution procedures, procedures for approving physical changes to the units, and finally, election procedures. So we just went through this whole discussion about the board adopting new election rules. Those would have to go through the same process that we're going to be talking about here. So the next slide talks about changes or a rule change. That's any change, any new policy, any amendment to existing policies in that list that we talked about. If the board is thinking about making a rule change, they must notify the membership at least 30 days before they consider taking a vote on that. This means that a board really needs to be thinking about changes that in those basic policies of operating the cooperative, because 30 days before, you have to already have the text of that planned change, because that 30-day notice must also include the text of your proposed change. Then at that meeting, all the members are welcome to attend and must be given an opportunity to speak to this rule change. Now, the board can put certain restrictions on how long members can speak, particularly if you have a lot of members showing up. The board may limit them to 1 or 2 minutes. It has to be a reasonable limit, but members have to be given the opportunity to address the proposed rule change. If the board decides to go ahead and approve that rule change, they must then again give notice of the new rule. That new rule can't take effect for 30 days. And during that 30 days, the members have a right to decide they really don't like that rule change. And if they can collect the signatures of at least 5% of the membership, they can call for a vote on the election, on the rule change. So, and if they do collect 5% of the signatures on a 100-unit project, that's 5 members. Then the board is required under Davis-Stirling to call an election in no more than 90 days. Between 35 and 90 days, they must hold an election. And at that election, the membership gets to decide, do they like this rule or not? And if the majority of the members vote to reverse that rule change, it does not go into effect. And in fact, the board then cannot reintroduce that same rule for 1 year. They could conceivably bring up the same issue but address it in a different way, hopefully taking into consideration the concerns that the members had, and maybe there would be no opposition now to a new rule, again, going through that whole same procedure. One important place where these rules about notification are different, and that's the case of an emergency rule change. And that must really there must be an imminent threat to public health or safety or a risk of substantial economic loss. You do not have to give the 30-day advance notice. This clearly would be an unusual situation. You would still need to notify the members of the new rule, but that rule cannot be in effect for more than 120 days. It gives the board the opportunity to deal with an emergency. It says imminent threat to public health and safety. You know, again, I don't even want to try and second guess it, but the board would make that decision, and it can't be, an emergency rule change cannot be challenged by the membership. You can't call for a vote on that. So this procedure, some people may feel it seems, I mean, I know Karen used the word onerous. I mean, sometimes you think, my gosh, you know, this is like so much bureaucracy, but the whole idea is this is part of the democratic process. You want to make sure that members are involved in decisions. You want to make sure there's transparency. So the board is providing the members a 30-day notice. We're considering this. The members are given an opportunity to express themselves. The board considers what has been said and then presumably passes a rule, and the members ultimately have a chance to call for a full vote. Now, if the board really feels like this was a good idea, they're probably advocating among members that it ought to be approved, but it is a bottom line, you know, the democratic process. Karen could try and address that. I think it would be very unusual that you would try and do an emergency increase in the carrying charges in a way that, because, you know, again, I think it was made clear if you're going to have an increase in carrying charges that are more than 5% of your operating budget or more than, you know, 20% overall increase, no, those would be covered by the other part. Board meetings should, well, not only should, they must be open to the membership, but board should really encourage member participation. The strongest co-op is one with active member participation. So The Davis-Stirling requires that you give notice a minimum of 4 days. Some co-ops may actually, in their bylaws, have a longer advance notice period. Davis-Stirling requires a minimum of 4 days notice. And that notice must give the time and place of the board meeting, but it also must include a copy of the agenda for that meeting. No issues that are not included in that agenda can be, no action can be taken on any issue unless it is considered an emergency issue. And again, emergency would mean that the board members would have had no reasonable opportunity to put that on the agenda at the time of notice. So again, it's going to be a pretty limited number of issues that could be added at the time of the meeting itself. So at any board meeting, members must be given an opportunity to address the issues. So there must be an opportunity for members to address issues. They cannot be expected to participate in the actual discussion of the board. But there's usually an open mic period where members can express themselves. The board then must have the opportunity to reasonably discuss an issue and take action on it. There is also a closed session or executive session that the board may use. Unfortunately, some boards, let's say, overuse this. When there are things that they would prefer members not to hear, they go into executive session. But Davis-Stirling states very clearly what can be discussed in executive session. And, you know, rather than repeating them, you can see them here. They really are things where there needs to be privacy. So, or perhaps, you know, where you're discussing litigation or contracts, where there's a real reason why you don't want this information public. But beyond that, you know, no other issues can be discussed in closed session. So I'm just going to close now by saying really that the board represents the interest of the members. They need to be accountable to the members. Transparency is really the key word here. And I also want, because I know a lot of you are board members, I want to shout out for board members. You know, it's a pretty thankless task. You know, I've been on boards, both co-op boards and other boards. You never hear from the members when things are going well. But when the smallest thing goes wrong, you're going to hear from them. And when you have that sort of open mic, often people come in and what are they complaining about? My refrigerator doesn't work. You know, they're not really looking at kind of big policy issues, which is what the board is trying to deal with. But by the same token, you know, so there needs to be respect among the membership for the board. The board also has to respect the membership. So it's a two-way street. It's really important. And the final thing, just Davis-Stirling provides the basic requirements. It's critical that the board understand it. Often, and I think Karen addressed this, it's property management that has to do these, but the board needs to know, the property management needs to know what to do. So the better the board understands those requirements, the more they can make sure that they're being properly carried out. And, you know, that sometimes they seem kind of a pain to have to go through, but often, in fact, they really represent a kind of a minimum, and the board should be looking for ways they can keep the membership informed, that they can perhaps even carry out a higher standard of transparency than what the minimum is required. So I think what we've tried to address here is what does Davis-Stirling require? And now I think we're open for your questions.